We're going to talk about something called torts tonight. We may even get into negligence, but we'll talk about torts. Torts is the civil counterpart to criminal law. For every criminal law, like assault, there is a tort, which in this case would be battery. So what good is it to duplicate these things? Well, the state prosecutes criminal offenses, does it not? The state prosecutes criminal offenses. Who do you think would have to prosecute a tort? The civil aspect of it means that individual people have to prosecute the actions. So torts are intended to recover money and ask for certain types of things to happen so that a person can be put back into the state they were in before whatever bad thing it was happened to them. Okay? But every crime has a tort that people can sue upon to put them back the way they should have been before it all happened. So let's go ahead and let's look at torts. Specifically, what is it? By definition, it's wrongful conduct by someone that causes some sort of an injury. Now, doesn't that sound like it could be a crime too? Well, yeah, that's why every crime has a civil counterpart in tort law, so that when this wrongful conduct occurs, and it occurs injury, it gives the injured party the right to bring a lawsuit against the wrongdoer to receive some sort of compensation for whatever injuries they've sustained. Okay? That's what a tort is. It's meant to be able to get ourselves back to where we were before any of this happened. What are the goals of tort law? Well, first of all, we want to compensate innocent, injured persons. If I'm sitting at a red light, and this has actually happened, and someone comes up and hits the car in back of me and shoves that car into me, and I hurt my neck, I need to be compensated because I'm an innocent, injured person. I was just sitting there, stopped. So I need to be put back to the way I was before that person wasn't paying attention and hit the car in back of me, which shoved that car into me, and I was hurt. It's supposed to prevent retaliation by injured people. It's supposed to keep me from going back, hunting them down, and doing them grievous bodily injury. The courts go out and make sure that I am compensated so that there's no need for me to seek out vengeance. That's not what we see in the movies, but that's what most of the time really happens. And it's to reinforce the vision of a just society and to deter future wrongs. Now, how can we use a lawsuit to deter future wrongs? Yeah, Larry.
My teaching was lesson about being careful.
That's right. And how is one of the major ways we do that? We're going to teach them not to do it again, but we have to do it in such a way that it's going to be so painful. Where are we going to hit them? In their wallet, in the pocketbook. That's where we're going to hit them. We're going to make it so expensive that that lesson that Larry wants to teach them is going to be able to keep them from doing it ever again, and everybody else around him is going to see that and say, I saw what just happened. I'm never going to do that. That's what bringing a lawsuit for a tort is all about. So, what is a statute and what is it designed to do? Because all torts these days are written into statutes. We've been talking about law, we've been talking about statutes. What's the statute? What is a general definition of a statute? What's a general definition of a statute? A legal statement. It's a legal statement. Okay. What does it say? What does it say? You have to do something or not do something, right? That's what you were trying to say. What else, Jillian? They change from state to state. That's right. So, we have statutes, and they're designed to tell us what we can and cannot do in certain situations. Yeah, Robert?
So like on the last assignment that you gave us, that one where it said that there weren't any fast food chains allowed in your state, would that be a statute?
That would be a statute. That would be a statute. And I will tell you, even though there are people in here who haven't quite turned in all their stuff yet, I will tell you that Oklahoma is not a good place to try and open a chain restaurant or a chain of any kind. It's very, very difficult. But that's all I'm going to say.
In regards to the homework, so that'd be dumb for him to like sue them, because you kind of like know how the law is.
Well, see, I'm not going to say anything about that because we're not done with that yet. Everybody hasn't turned it in yet. But I will tell everybody about what I was thinking when I put that up there. So, what is a duty owed to others? What is a duty? Give me an example of a duty that we owe to other people. Larry?
Would it be like the military, they hold a duty for the fight for the near?
That's an example of that. That's an example of a duty that is owed to all of us. What other kinds of duties do we have? Caring.
Jury duty.
Jury duty. Robert?
Ethical duty.
An ethical duty? Yes. Let's make it really simple. When you're driving down the road and you see a traffic sign that says 30 miles an hour. 30 miles an hour. What is the duty that's owed to everybody else on the road? You stay within that speed limit so you keep yourself and others safe. That is correct. That is the duty that's owed to everyone else on the road. Now, where does that duty originate? Where does that duty originate? The law and in, and we studied it, second section. Starts with an E. Ethics. You have both law and ethics. Okay? So, a duty owed to others originates in both law and ethics. Let's talk about classifications of torts. What kind of torts do we have? Well, intentional torts occur when a defendant takes an action that's intended that certain consequences are going to occur, and they know they're going to occur. So that's intentional. Someone comes up and says, I'm going to hit this guy. Well, he knows that when he brings his arm back, follows through and hits the guy, that was intentional. He thought about it ahead of time. Right? Negligent torts. Negligent torts occur when the defendant fails to act responsibly. That subjects other people to an unreasonable or unknown risk of harm. So that's a negligent tort. Negligence is something we have a little section on after the main section on torts here that talks about how another name for negligence is accident. They're acting in a certain way that causes it to be accidental conduct. So that's what a negligent tort is. It's no less a tort because somebody can get hurt, right? And they have to be compensated so they can be put back into the wholesome way they were before it ever happened. Strict liability torts. A strict liability tort is a special tort. It occurs when a defendant untakes some inherently dangerous action causing harm to others. Strict liability does not happen very often. But we will talk about it. We'll talk about examples of it. And I will give you one right now, just so you know what this is like. A farmer has a new bull, and he is told that bull is a very, very strong and anxious, nervous animal. So he puts it into a corral all by itself, into a pen, into a field. And he locks the gate with a light chain and a padlock. And a truck drives in that has cows that are going to be delivered to that same farmer. The bull sees the cows coming out of the trailer and charges across the field and smashes open the gate because it was just a light chain holding it. And in an attempt to take over the herd as his own, injures the driver of the vehicle that brought them. Now, the farmer has been warned that that animal was anxious and nervous and very strong and very domineering. Well, that could be a strict liability tort because that bull was inherently dangerous and did in fact end up causing harm to another. Okay? May have even done some property damage at the same time. So, that is a strict liability tort. Negligent torts are like traffic accidents. And intentional torts are something that happen because somebody thought about them ahead of time. Okay. Intentional torts. These are torts against persons. Now we're also going to talk about torts against property. That's when we really get into talking about torts that involve business. Assault. Assault is when someone is put in apprehension or fear of someone else because they believe that they are going to be hurt. Now, I just used two different terms. I used the term fear and I used the term apprehension, didn't I? What is the difference? Let's talk about fear first. What is fear? What is fear? Jillian. Fear is an emotion. That's a very good definition. Fear is when we have a chemical, physical reaction that tells us that we could be hurt. We are pretty sure that we're going to be hurt, and we're going to be injured. Fear is an emotional reaction, emotional and physical chemical reaction. So, what then is apprehension? If fear is emotional, what is apprehension?
That's more like being scared of something in the future, right?
It's like being scared of something because you know it's going to happen, or you think it's going to happen, whether it actually happens or not. Right? That was good. So apprehension is an intellectual or thought process. Fear is an emotional, physical process. So assault can either consist of being afraid of something emotionally or being apprehensive that something is going to happen. Battery is a physical touching. See, assault is not necessarily a touching, is it? That assault can actually just be the fear or the apprehension that something is going to happen. Battery is when somebody touches someone and hurts them. This is the fear of being hit or the apprehension that one is going to be hit. This is when they're actually hit. So assault and battery are two separate torts, and we can separate them for purposes of legal action. Defamation. Defamation. What is defamation? Robert.
Speaking badly about somebody else's character.
Speaking badly about someone else's character. And that comes in two flavors also. It can be slanderous, which is vocal and speaking the words that say that something is bad about some person. Or it can be libelous, and libelous is written. We'll go through these again, but we'll just give you a general idea as we're going through them. Libel is written. Slander is spoken, but they are both defamation. Invasion of privacy, also sometimes called false light, public disclosure of private facts, misappropriation of commercial gain, and intrusion on an individual's affairs. Well, false light, that's when somebody says something that makes other people think that they're not a good person, for example. And it can apply to a business. How many of you write up reviews of restaurants that you put on the internet? Okay, there are a couple of you. What app do you use? Is it Yelp? A lot of people use Yelp. Some people use another app. If it is wrong and based only on one opinion, it's called false light. You're putting the business into a false light, which is not true, and can cause other people to think badly of it. And here's a really strange example. There was an individual who was starting a restaurant, okay? And that individual was just getting the restaurant built, hadn't even opened yet, but they were already getting reviews on Yelp that said, oh, this is a horrible restaurant, they don't know what they're doing, the service was lousy. It wasn't set to open for 6 months. 6 months. Yes. Yeah. Who was say it loud?
Steph Curry's wife, because
Yeah.
Houston fans
Uh-huh.
lost instead of putting bad review, and the restaurant hasn't even opened.
Yeah, the restaurant it's still not open yet. They're still working on it.
What happened?
But Steven's wife is getting bad reviews for her restaurant already. So she's found out who they were. And here's the thing, she's filed a lawsuit for false light. And she can get the names of all those people and their IP addresses, because in a legal action, you can subpoena that information from the website. Okay? Public disclosure of private facts. This is all the stuff that we don't want to have come out about our private lives. Oh my goodness. Okay, so we get into a lousy relationship, and we decide that it's not going anywhere, so we decide to break up with our partner. And they're okay with it, and we're okay with it. But somebody out there is not okay with this. They disclose all the private facts that they think caused the breakup. Well, that's public disclosure of private facts. And both parties can go after that person for that. Misappropriation for commercial gain. Misappropriation for commercial gain means someone's taken my photograph and decided to use it to promote a product. There is a photograph right now that has been used on the internet for, I don't know, 120 different products, advertising it, giving information about various products and saying, I use this product. That person's never even heard of these products. And it's come up, it came up on the news, and now they're suing too for misappropriation of their photograph for commercial gain. And we're allowed to do that. We're private citizens. We're allowed to have a private life. And anyone that misappropriates our photograph for commercial gain, particularly, and not just for creating a false website on Facebook or something to try and get people's contact information. We always have to work on avoiding that. But if it's for sale of something, then it's very special, and we can sue for that. And that's a version of invasion of privacy. And then intrusion on an individual's affairs. Even celebrities are allowed to have a private life. So paparazzi come up and they stick a camera in your face. And they're there all the time, 24 hours a day. They camp outside your apartment. They see you when you come out to go to the gym. Maybe you're not looking quite your best. Or maybe they see you when you're going out for dinner with a new date or something like that. And they're always taking these photographs and getting in your face. Well, isn't that intrusion on your private affairs? Well, that would be invasion of privacy. That's why there's a lot of success, especially when celebrities sue tabloid newspapers for various reasons. They sue them, they can recover if what the tabloid newspaper says is not true, and they can prove it. False imprisonment. False imprisonment is when someone is restricted to, say, the confines of their own home through no fault of their own. Somebody is forcing them to stay there in that place under threat or duress. Okay? I've got an example of this, which I will tell you. Yeah.
So what's the difference between kidnapping and false?
False imprisonment makes them stay in one place. Kidnapping is taking that person and moving them, and that's a criminal. First of all, this is civil, tort. Kidnapping is criminal. There is an analogous tort, but kidnapping is when a person is taken from one place forcibly to another. It can be as slight a movement as from one room to the next. Can still be considered kidnapping, depending on how the statute is worded. That's why we always have to go back to the statute. Okay? But that's what kidnapping is. This is by threat or duress. A person voluntarily stays in their, say, their own home, but they're afraid to leave. Again, it goes back to fear of what's going to happen to them, or apprehension of what's going to happen to them. Okay? Anything else on that one? Is that okay? All right. And then there's intentional infliction of emotional distress, which I will explain in an example that sounds like I made it up, but I didn't. And then misuse of legal procedure. And I'll just tell you that misuse of legal procedure is when somebody comes up and files criminal charges against somebody who's completely innocent or didn't do anything, just to make them do what they want them to do. Then the person can take them to court and sue them for misuse of legal process. Okay? That's fairly one of the easier ones to understand. Intentional torts against property are trespass to realty, private nuisance, trespass to personal property, and conversion. So trespass to realty, what's that? Well, that's the person who comes stomping across your yard at 3 o'clock in the morning because it's easier to take a shortcut from the corner through your yard to get to their house. That's trespass to realty. They don't have permission to do that. They just do it because they want to. That's trespass to realty. In business, a person can be charged with trespass to realty if, say, it is an establishment that serves liquor and beer and wine, and the establishment tells them to leave and they refuse. The police can be called and they can be arrested for trespass. That is the criminal part. Then the shopkeeper can sue them for trespass to realty, because the fuss that that person's putting up is bound to have caused some patrons to leave, and they're losing business. Right? So does that make sense? Most of these make sense all by themselves. Private nuisance. Nuisance we referred to when we were talking about environmental laws. Nuisance, what is a nuisance? If I spend all my time over at your house, am I being a nuisance? Yeah, of course. Because I'm always telling you, you got to get your work done. I'm always telling you, you got to get your paper done. I'm always saying, why are you going out to play basketball when you should be doing your homework? You know, I'm a nuisance that way. A nuisance and property, private nuisance, is something that is set up or becomes somebody or something close to you that causes you to feel anxious and nervous, and you can't use your property the way you want to do it, and it's just awful. For example, I grow roses. I don't really. But I have a neighbor who does. My neighbor grows roses. And a new neighbor moved in next to them who decided that there was too much water during rains on their property, and so they were going to let it go down their driveway. So they had their gutters fixed, and they got those long, flexible plastic pipes, and they ran it all over to their driveway, and it looked like a doggone river coming down there when it rained. And the lady who grew the roses was growing championship roses. Okay? These are roses that she would take to shows, and she would win prizes with these roses. And it actually gave her money for her retirement. So the water, you can't have too much water on roses. It washes the soil away, and when the soil is washed away, then the roots are exposed, and when the roots are exposed, it's going to cause a problem with the roses growing. They'll die. The whole entire bushes are going to die. She sued the new neighbor for private nuisance, because that's pretty much what it was a nuisance. And she won. And the neighbor had to reroute all of her water from the driveway back onto her own property, and now it flows down the front yard the way it was supposed to. Okay? Trespass to personal property. Trespass to personal property. Trespass to personal property is when an individual will take something that doesn't belong to them with a person's permission initially. So if someone comes over to my house and says, my husband is turning 40 and I'm borrowing all the neighbors' pink plastic flamingos so that we can put 40 pink plastic flamingos and a big flashing sign on our front yard, and we want to borrow your flamingos, we'll bring them right back. They put the pink plastic flamingos on there, and they leave them there, and they have the sign, and there's a big party, and everybody has a lot of fun. Until they forget to bring them back. Now, it's not intentional initially, but they decide that they're such great souvenirs that they will keep them for a little while. That's trespass to personal property. I can sue them to get my pink plastic flamingos back. They don't have much value, but we'll try and get some nominal dollars out of it so that they'll never do this again. So we say, okay, a nominal lawsuit, about $25, get them to pay it back, and that'll settle it. But that was trespass to property. They didn't intend to keep it initially, but it's still an intentional tort because eventually they intended to keep them for a while. Now, where is the difference between that and conversion? Conversion is a stronger form of trespass to personal property. Instead of just borrowing the pink plastic flamingos for a little while and eventually intending to give them back, they take them and they keep them and they never intend to bring them back. They're going to keep them for a souvenir forever and ever and ever. That is conversion. When somebody takes something, it's like theft. It's like the civil version of theft. They take it, they never intend to bring it back. Okay? That is conversion. Now, do you see the difference between trespass to personal property and conversion? In trespass to personal property, they do intend to bring it back after a little while, and then they forget, but they still intended to bring it back. Conversion, they never intended to bring it back from the very beginning. They can say they did, but if it's been long enough, the judge or the jury isn't going to believe them. See, it becomes a this person said versus that person said kind of an issue. So we also have intentional torts against business economic interests. The first one is called disparagement. Disparagement, yes. Disparagement, individual slanders or libels a product, such as once there was a manufacturer who took out a full page ad that said that Tylenol consisted of substances which were in fact morphine derivatives. That was totally untrue. And it slandered the product to the point where people did not want to buy or use Tylenol. The makers of Tylenol sued the individuals who took out the ad, and one of the things that the people who took out the ad had to do was publish another ad of equal size in all the same newspapers that said, "We lied." In big letters, "We lied." Intentional interference with a contract. This is when somebody tries to convince a party to a contract that the contract they have right now is no good. For example, right now there's a controversy with Nike, is there not? Lots of people are trying to convince other people that Nike products are no good and they shouldn't buy them and they should sell their stock in the company. They're trying to interfere with the contract between the people who retail Nike and who are distributors of Nike. These are third parties that have nothing to do with either one of the two. Have nothing to do with Nike, but they're trying to influence them. That could be intentional interference with the contract between the supplier and the retailer. Trying to convince them that their product is no good. And oh, by the way, guess what? I have an Adidas distributor over here who would love to make up the difference in your sales. Now you've got them. Because they've tried to substitute another party for Nike. By the way, you all know what's happened with Nike in the last few days, right? Their sales have gone up by 33%. Yeah, and the stock price has gone up. And it makes everybody who was saying all those things look extremely foolish at the best. Unfair competition. Unfair competition. This is when I have a food truck and I'm parked in my normal food truck spot and somebody comes up and parks not just right next to me, but halfway over into my spot so that nobody can see that my food truck is there. I'm going to lose sales. That's unfair competition. Because they've taken some affirmative action to ensure that the original food truck could not be seen. It could not be accessed. Misappropriation. We have misappropriation suits being brought all the time, and a lot of times it has to do with trade names. If there's a trade name that's under copyright, it's not supposed to be used by somebody else, right? So let's say we have a version of chicken wings that we're going to freeze and put on the market. And we call ours Acme Chicken Wings. And somebody else comes out and says, well, we have a chicken product too. We have drumsticks, turkey drumsticks, and we're going to put them on the market as Acme Turkey Drumsticks. But they're not the same company. Could there be product confusion there? Could we think that the same people that are putting up the chicken wings are putting up the drumsticks? Sure. We could even say that one company has tried to misappropriate the business of the other company by having a similar product. That has to be settled in court. Then fraudulent misrepresentation. Fraudulent misrepresentation is when somebody has a product and they talk about it and they say all sorts of things about it and they're all lies. For example, this actually happened. And we'll talk about this when we talk about negligence and strict liability again, or consumer law. There was an exercise bicycle. And it was set up to do certain kinds of exercise. And a person went in and they saw this exercise bicycle, which would have been advertised in the newspaper or online. I can't remember which one it was. And they went into the store and the salesperson said, oh yes, it will do this, 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 and this. Some of those things were true and some of them were not. Well, the person took it home, and the salesperson did this deliberately, trying to sell this particular exercise item. They took it home, they tried to use it both for the things it could do and the things it couldn't do, and on one of the things that it wasn't supposed to be used for, it broke, and the individual was injured. The salesman knew that it would not do those things. He lied about it, and the person was injured. The fact that he told them that it would do that, and he knew it wouldn't do that, makes it fraud. Okay? So that's fraudulent misrepresentation. Yes, Robert.
How come nothing ever happened in the subway for the fraudulent misrepresentation?
Of what?
Because when Jared was still their spokesperson, they were straight up saying like eating something will make you lose weight. Literally, he was like exercising and dieting properly.
I don't know whether or not anything did or did not happen to him. There's a difference between fraudulent misrepresentation, which is knowingly misrepresenting a product, and something we call puffing. Puffing is when a person is giving their opinion. In that case, Subway in those ads could have said that it was their opinion that Jared was losing weight because he was eating Subway. The rest of Jared's lifestyle was not under scrutiny.
So just a loophole pretty much.
So it's a loophole. It's called puffing. And that happens with products all the time. If you ever see any of the old cigarette ads from the 50s and the 60s, Lucky Strike, the best tobacco, and it's good for you too. Well, we know that there are carcinogens in the tobacco. But Lucky Strike was puffing up their product. Whether they knowingly said that or not, Well, it was proved that they, eventually proved that they did know that the insecticides and the pesticides and all the stuff that was used, and even the tobacco itself pulled things out of the soil that were harmful. But initially in the ads, that was thought to be routine. And so they referred to it as puffing. And it didn't go to a consumer-oriented decision for many years until it was in the 70s and 80s. And they actually had the medical evidence to prove it. Then things changed. So what kind of damages do we have? We have compensatory damages. Those are awards that put plaintiffs in the same position they would have been had they never had this thing happen to them. We have nominal damages. That's when the person comes over and steals my pink plastic flamingos, and I have to sue them to get them back, and I sue for nominal damages. Okay, we're just going to take them to court, get the flamingos back, charge them $25 for any damages that may have happened to the flamingos, and I get my flamingos back. Nominal damages are minimal. They signify that the defendant's behavior was wrongful and didn't actually cause much harm. It's more like a slap on the wrist. But the judge has told them, you were wrong. And sometimes that's all people want when they go to court. Then punitive damages. Punitive damages are damages that punish defendants seeking to deter conduct in the future. These kind of damages can go into the millions of dollars. Why is that? Because we want to make these people and people who are doing similar things never to want to do it again. Okay? Society recognizes that we all have an interest in each other's safety. Yes?
What you just said, is it more based on like the circumstance or just how the person is feeling, on like how they want the other person to like pay for what they do?
There's a lot of subjectivity to it. Because if I just want to have the judge say that I was right, then I'll just go for nominal damages. If there was some actual economic damage where something was damaged, like when they were stealing my pink plastic flamingos, they did it with a bucket loader and they ran over my front porch and destroyed it. Well, then we're going to have to seek compensatory damages so that that can be rebuilt. And then we're going to want punitive damages so that person will never do it again. So compensatory and punitives are in the mix, and forget about the minimal damages. Okay? So yes, it is partially realism and partially subjective as to what the individual who had things done to them will sue for. It's a very good point. Tort law provides remedies for acts that cause physical injury and that invade or interfere with physical security and freedom of movement. Freedom of movement is what we call the imprisonment, false imprisonment. Now, let me tell you a story about false imprisonment. False imprisonment, when I was back in Ohio practicing law actively, we had a young man in a small town, and he was a real genius at fixing things. You know, there's all kinds of genius. There's book genius, there's baking genius, there's repairing genius, there's computer genius, there's all kinds of genius. We all have our own form of genius. Some of us, we don't discover it as soon as others, but we all have some. And his greatest physical aptitude was being able to repair anything. So he had a fix-it shop in a small location on the edge of this small town. And people would take everything out to him, from lawnmowers to tractors to radios, to stereos, to VCRs, everything. And he and a couple of his buddies would fix them up, charge him for it, and send them back. He was really great. But there were some guys that he had been in high school with that were doing the same thing downtown. They weren't really quite so good at it, but people were afraid not to pay their rather exorbitant prices because they were very physically imposing and demanding. We can call them bullies. And they went to this guy on the outskirts of town who was, typical, looked like, he was a geek. And they threatened him. And they told him that they were going to watch his house. And if he came down to his shop and tried to open it up, they were going to hurt him physically. He was afraid. He was really afraid. And I don't know why he didn't think to call the sheriff, but he called me because I had been his attorney. He said, "What do I do about these guys?" I said, "Let's go to court and we'll bring the sheriff in and we'll get an order restraining them from ever approaching you again, and that should be the end of it. Sometimes all it takes is the court to say, 'We know you're doing this, stop it.'" And so we did that, and these guys didn't stop it. And they actually would drive up and down the street in front of his house. And he really got scared. He really got scared. So we decided that we were just going to have to go ahead and sue them for false imprisonment. And we did that. And these guys lost their shop downtown, so now my client had two locations, one on the outside of town, one in the center of town. Everybody got fair prices. And the guys that owned that shop in the middle of town that were bullying him got put in the back of a sheriff's car, driven to the edge of the county, and were told by the sheriff never to come back. He just said, "Keep going." And they did. They didn't come back. At least, last time I checked, they hadn't come back. Society also recognizes that property, privacy, and personal dignity need to be protected. So with intentional torts, we always have to have intent. And intent is a mental state in which the tortfeasor, this is the person who's going to commit the tort, knows the nature and consequences of what they are about to do, but they do it anyway. There doesn't have to be a motive for the act. So, if somebody comes up and sees a car parked in someone's driveway and decides that they need to trim branches off their tree, and they take their chainsaw and they go up on the side of that tree and they cut that branch off and it falls on their neighbor's car, is that an intentional tort? Did they intend to harm that property, or did they just intend to cut their branch? This is a trick question. Yes, there is going to be damage to the neighbor's car. Was it intentional? No. That's what negligence is for. Negligence is an accident. Nobody wants it to happen, but it happens anyway. Okay? So, when there is an intentional tort, there does not need to be a motive for the tort. In fact, sometimes they are in a position where the tort can be defended. For example, if an intentional tort is committed while an individual is intoxicated, do you think they are going to be allowed to escape without consequences? The answer is as Robert says, no. No, there will be consequences, either criminal consequences or tortious consequences. If there is a criminal case that's brought and they are found to be in violation of the law, the likelihood is that they will also be made to pay for the damage to the neighbor's car, or whoever they hit, or if they damage somebody physically. Now, torts can be broken down into elements. Elements, when we see a statute, each element is a sentence in the statute. Each one of those sentences are elements. And when we put them all together, we have what we call a prima facie case. That's what we need to bring it to court, is a prima facie case. In other words, a basic case. If one of those elements are missing, we cannot bring it into court. Okay? Have any questions on that? Because we're going to start breaking down some of these intentional torts into their prima facie cases, and I'll show you how that works. All right? Start with battery. Battery says, and I'm going to read this the way the statute would say it, because the statute doesn't break it down into individual pieces like this. Battery is a reasonable apprehension or fear of immediate harmful or offensive contact made by the defendant or some force the defendant sets in motion and is completed. Now, there are 5 elements to battery. The first one, it has to be reasonable. What is reasonable? Reasonable is a state of mind that is under consideration by the jury. Reasonability is a standard of judgment. Reasonable means what all those jurors would find to be reasonable under those particular circumstances. So if I find it to be reasonable, and Zach finds it to be reasonable, and Malcolm finds it to be reasonable, and Robert finds it to be reasonable, and we're all on the same jury, then that's what's reasonable. We all have to decide what is reasonable. So battery first has to be reasonable. In other words, somebody touched somebody else in an offensive manner. And we all found out that it was reasonable because we talked about it in the jury room. It has to be apprehension or fear. Apprehension, again, is a mental idea which says that we know it's going to happen, we don't want it to happen, but we think it's going to happen. That's apprehension. We're not afraid yet, or we don't have to be afraid at all. Fear, on the other hand, is the emotional content. We might be afraid of the battery. We might be afraid that we're going to be hit. It's emotional. The third element is immediate harmful or offensive contact. Okay? Offensive or harmful contact. If somebody hits somebody else, that is harmful contact. Because they can be hurt, they can start bleeding, they can break a tooth, they can break their jaw, ribs, whatever's hit, right? So that's harmful. But there was a time when I went into a restaurant, and the restaurant had a sign on it that says smoking section and non-smoking section. And somebody in the non-smoking section decided they were going to start smoking. And the person next to them in the non-smoking section got violently ill because they were allergic to tobacco smoke. Now, was that harmful? Could they have been apprehensive when that started to happen, when they saw the person light up? Were they touched? by that smoke. See, that's the key. They were touched by the smoke, which is something harmful, and it made contact and made them sick. So these three so far were good. They were part of the prima facie case. Then, it's made by the defendant or some force the defendant set in motion. The smoke from the cigarette was smoked by the defendant. We're going to bring that defendant into court, and we are going to show that they were the ones smoking it, set it in motion, and it blew into the person's face. And was completed. It did touch the person's face. It did inhale it. It did harm them. Okay? See how that goes? So this is our prima facie case. These 5 elements. What happens if any one of those elements is missing? You don't have a case. That's right. There is no battery. Very good. There is no battery if one of these elements is missing. Any one of them. If I am neither fearful or apprehensive, I'm just ticked off. That's not battery. You know? Yeah, you've probably come up with someone and they start blowing smoke in your face, or they get you aggravated. Well, aggravation is not harmful touching. You're just aggravated. So there is no prima facie case for battery there. All right? Compensation for battery is inclusive of more than just compensation for physical harm, because we want to teach them a lesson. We want to show them that they can't do that to us anymore or anybody else. So we're going to have punitive damages. Punitive damages are damages which are so high and so large that, by golly, they're never going to want to do this again. Okay? Let's talk about defenses to battery. Now I have football players up here playing football. Somehow I'm thinking, anybody from Chicago in here? I am so disappointed. I mean, the Bears had them. The Bears had them last night, and something happened. I don't know what it was. Oh, I know what it was. I went to bed right at the end of the third quarter. And since I wasn't there to coach them through the fourth quarter in front of my TV, they lost. I wasn't there to tell them who to substitute. So, football players. Football players play a really rough game. And they have rules, right? One of our rules is consent. When those football players go out on that field, they know they're going to play a rough game, and they sign a waiver and legal forms before they ever take the field, before they even start practice, that says, I understand this is a rough sport and there could be injuries. All right? That is consent. So a defense to battery could be consent. Race car drivers like to slam into each other on the racetrack sometimes, don't they? But race car drivers sign consent forms when they enter a race that say, if I am injured during the course of the race, I cannot sue the other driver. Now, they may have to go to arbitration or mediation if it's serious enough in order to be compensated for their injuries. But that's different. We already talked about that last time.
Right. Even if it was like intentional, to do that, like even though sometimes it's like, okay, you can't do it, but let's got something that to hit them in certain spots so that they could be injured from that.
Okay. What Shri is asking is, don't drivers have a plan when they go out on the track, especially if they're like team driving, to sometimes trap other drivers so that they will be forced out of the race. And sometimes those plans, which are not intended to go bad, do. Now, is there some way to recover for that? Well, that's part of the contract, that's part of the mediation, and if someone is injured doing that, then a lot of the drivers are really angry at the other driver and they end up ganging up on them. I've seen that happen. But that falls under their contract rights, and their contract rights allows some consent to that kind of action. Okay? Self-defense, defense to battery. Self-defense is the same as it is criminally, except there is no stand your ground law in civil law, only in criminal law. So self-defense means if you defend yourself, you must do it with equal or lesser force. And that equal or lesser force must be the only force necessary to disengage from the action. Yes, Robert?
Recently, there was a case where this woman went into the wrong house, and she was a police officer, and she ended up shooting this guy, killing him, because she thought it was her house, but it was actually his house. Like, is there any argument that she would be able to give in court based on defense, or is it just straight up manslaughter?
She has been arrested for manslaughter. Her family, if they are really, really good, has already retained an attorney. And they will be suing her, and she was in uniform. They will be suing the city, and they will be suing whoever they can find as compensation for that.
So there's no kind of defense argument on her part that she could play?
Yeah, confusion, intoxication, if she was. We'll see what they come up with, because there could be some sort of something that the defense has a duty to always zealously defend their client, and I never know what these attorneys are going to come up with. Yeah.
That's not gonna work. She just said that he didn't follow her orders.
He didn't follow her orders, but it was his own house.
Isn't there were some people saying, I think maybe that she had some personal relationship with the guy?
Yeah, she
They
knew.
met up before, they've been together before.
Well, that may show up in court, so we'll
Oh,
see.
that was gone, she would be cute.
Wait,
Not in your house. No, she needs to be cute, and I would put her as the shocker, show her what she at home.
She's only been charged with manslaughter, Larry.
Well, she should be, like, that's like me.
Look, I understand. Let's move on. We're talking about courts here. Well, if you want to next week, you'll be able to hear what you said on the recording. Defense of others. Defense of others. What is defense of others? Defense of others is just like self-defense, except you're defending somebody else. So if my son is in trouble and somebody's threatening my son and he's not in a position to defend himself, I can step in and defend him. I take on all of his self-defense rights in addition to any that I have for myself. But I am allowed to step in and try and talk the person out of it, or if I have to do whatever I need to do to defend him. Okay? That's defense of others. It generally involves weaker individuals or individuals who are injured and not able to defend themselves. Defense of property. People from Texas here? Anybody? Oh, so then you don't know about this. Oh, Jillian's from Texas. What do you know about defensive property in Texas? Okay, here's the story.
What does it mean?
What does it mean? You will find out. In Texas, there was a gentleman who was having trouble with some of the neighborhood hooligans coming over and hanging around his property. And it's not that he didn't like that, but they were damaging his shrubbery, his grass, his car, all sorts of things. Scratching up the car, he was going to have the car repainted. And so what he said was, he went out and said, guys, get off my car, get away from this particular corner. You're on my security cameras. I'm going to call the sheriff. And they just laughed. He did call the sheriff. Sheriff came out, talked to the guys, said, you got to get out of here because he has the right of defense of property. 2 nights later, to spite him, these guys came back and they took a screwdriver and they took paint off his car. And that was it. That was the end. He felt threatened. His wife and children couldn't leave the house because they were loud and threatening. And he went out, he had a Colt 45 Peacemaker, he shot all 6 of them.
And he wasn't charged, right?
And he was not charged.
Yeah, my dad, okay, he didn't do that, but sometimes, okay. It was.
Remind me of where not to go in your neighborhood.
So like my dad, it was like I was like in 4th grade, it was like a snow day in Texas, and there was like actually snow out for like, 24, 48 hours. And some like guy came into like our yard, and I remember my dad was watching us from upstairs, so like, he literally like, he's always had guns, he done that before. But he didn't shoot him, he just warned him.
Warning, yeah. That's like Clint Eastwood going out on "Get Off My Lawn," you know, in that.
And that was part of his dad.
That was, he probably took that line from your dad.
He just said, he was like, if you don't move in 5 seconds, I'll shoot you. And I got it right, and we had to go inside and get that.
That's quite a story. Robert.
Because of all honesty, we kind of have a 2-part defending property rule, where like if you hurt someone or kill someone while they're on your property, you have to go to court for it, but you're more than likely gonna win. But apparently if you harm someone, like if they're inside your bedroom, it's like an open shut case, like if they're not supposed to be in your bedroom, then you just automatically get off of it.
That used to be the same thing here in the United States. It used to be that when someone invades your home, and you are home and your family is home, you are defending your family. These days, it's just as likely that the person who defends their family or defends themselves in their own home is going to be charged with manslaughter. It's just as likely. And then we have all the civil consequences that go along with that, and we have to allege self-defense and defense of our family and defense of others and that sort of thing. But defense of property never, in I think 49 other states, that's why I bring up Texas, 49 other states does not apply. You go to Massachusetts and try and defend your property with a firearm, and you're in jail. Period. False imprisonment. This is the one I told you about, where the guy was inside his house and couldn't get to his job and ended up owning the other guy's job as well. Yeah, Sheree.
I have a question. So, what if, you're at home, and the police don't have a search warrant, but they're trying to steal property, like, getting your house, can you shoot them?
No.
I'm just saying.
You better not. No, it's never a good idea if anyone identifies himself as a police officer and you cannot see them, you call 911 and ask if there's any police activity in your area because there's somebody knocking on your door claiming to be a police officer and you're afraid to open the door. They will tell you. They have to tell you. Okay? So false imprisonment, intentional confinement or restraint of another's activities without justification, involving interference with the freedom to move without restraint, and it's unwilling. Do you get all of that from that prior story that I told you? Where the person was in his house and was unable to leave? because he was being restrained by, I'll move on. Intentional infliction of emotional distress. It's called the tort of outrage. And the elements are an intentional act that amounts to extreme and outrageous conduct, resulting in severe emotional distress to another. Okay, so those are the four elements. Let me tell you, the story I'm about to tell you sounds like I made it up. I did not. This actually happened in Detroit. While I was in law school, we were asked to go up and help the police investigate because they weren't sure if it was a crime or if it was just a tort. An activity that had happened up there in 1988-89. So several of us who were older and fairly diplomatic in our mannerisms went up and found a very unusual situation. What had happened was there was a family, and the elder patriarch, the grandfather of the family, passed away. And he was taken to a funeral home. And he was made ready for burial. His family went in, as families do, and they picked out a lovely casket for him to be taken to the church in and to have a wake in, and had all the arrangements made, had his clothes picked out and all that sort of thing, and then they had him all ready for burial. And they went to the church, and then they took him back. There's some strange thing, oddest behavior. The funeral director demanded that they go back to the funeral home because they'd forgotten something. And they took the casket back into the funeral home, and it was covered with a flag. It was covered with the U.S. flag because grandfather had been a veteran. And so a few minutes later, they brought the casket back out and put it into the hearse. Well, it was raining. It was raining like it rained here on Saturday. So you know what I mean. And the water was just everywhere. And so they drove out to the cemetery to do the graveside service. And the pallbearers lined up along both sides of the hearse to receive the casket. Well, the casket, it came out, and they took a hold of the handles, and it was wet, so the grip wasn't good. And they put it down on the ground and to get a better grip. But the ground was wet. And so when they picked up the casket came up, and Grandpa was still on the ground.
What kind of casket is this?
They had switched the casket that the family had picked with a cardboard casket normally used for the interment of individuals who are either unknown or indigent.
I'm sorry, but that would have been like crazy if I was.
See, I told you that this would be hard to believe. It sounds like I made this up, but I didn't. This is actually. And the wife passed out and had severe emotional trauma. His daughter, not only did she pass out, but she hit a gravestone with her head and had a concussion and cut open. And there were several other emotional injuries and physical injuries because of this severe sight. Well, the sheriff said, "Is there something criminal here?" And we said, "Heck yes."
They switched up the casket.
One, they stole the casket. Two, they abused the body. Three, people were injured as a result. And so we said, "You also have a tort." The family attorney happened to be there, and we started discussing this tort with him because That was an intentional act to switch the caskets. It was intentional. He was going to resell it. He was going to use it a second time and resell it to somebody else. Now, they probably would have been switched out too, but he was making a fortune on this. It was extreme and outrageous conduct. Can we all agree that that was extreme and outrageous? And it sounds like the professor made this up, but he didn't. Yeah, that was extreme and outrageous. It resulted in severe emotional distress and physical injury. And it was to members of the family, to others.
Did you go to jail?
Can you go to jail? He did. He was arrested on the spot. He was not even allowed to get back into his funeral home to collect his belongings. He was arrested in the cemetery by the sheriff's escort and was taken to the county jail, and he was tried within 2 weeks, and he was found guilty, and he went to county jail.
For how long?
He went to county jail for 18 months. But he lost his license. He had to sell the funeral home. He had no way of making a living. It was severe.
I'm sure you could have gotten a job.
Well, maybe he could get another job, Sheree, but
It's not gonna be a funeral home, but I don't know.
I don't know. We'll have to see. I don't know what happened after that. Defamation. The wrongful harming of someone else's reputation. Okay? Wrongful harming of another's reputation. It can be oral or it can be in writing. Oral defamation is called slander. If it's in writing, it's called libel. But either way, whether it's spoken or it's written, it has to be published. Now, if someone is yelling somebody at somebody in the parking lot and saying nasty things, and there could possibly be someone there who could hear it, it's being published. If it's in writing, and it's in a magazine, it's in a notebook that people are going to read, it's on the internet, just anything like that, it's published. Oh, and a special thing about the internet. What people write never goes away. That's why when you go to get a job, when you leave Fisk, or even while you are at Fisk, sanitize all of your accounts. Make sure that you don't have all those wonderful party pictures from last weekend on your Facebook page. And I got people reaching for their phones right now. I'll clean this off right now. You know why? There is a whole industry in HR devoted to data mining in people's social media. Whether it's Twitter, whether it's Facebook. Oh, and that one that's supposed to disappear after 7 seconds? Snapchat?
So where it goes?
It's all on their servers. It's all on their servers forever, and it can be recovered.
I think so, because you know, if y'all get that like 2 years ago, we did it like this year.
With Facebook?
But that's if you
No, that's
save
on
it to your memory.
So there are some that are real, there's some that are not, but it's all on the internet somewhere. That's why we have to be very careful with defamation. Yeah, Robert.
There was this app that came out like a while ago. Sasha was telling me about. If you like log onto your Facebook account on it, it'll show you like every single conversation, picture, post that you've ever deleted. Like it recovers all of it and shows everything to you.
You can just search.
I'm not surprised that, you know, that there's an app out there that will recover everything that you've ever done. Yeah, that's what some HR departments will do. So be very, very careful, okay? How are some damages designed to operate in tort law in general? Well, in defamation, they act the same way they do in the other intentional torts. If it's libel, it's the same type of damages. If it's slander, however, special slander laws pertain in each state. If it's a federal slander suit, you can recover up to 3 times the requested damages. So in federal court, if I sue someone for slander and I sue for $1 million and win, I get $3 million. In Tennessee, if I sue in state court for slander and I sue for $1 million, I win $2 million because it's twice the number of damages you ask for. And generally, that's true throughout the United States. So, to recover damages in a defamation case in libel, the plaintiff doesn't have to prove that they were actually injured in any way from the libelous statement. They only have to prove that it was made. Again, it may be a they said and they said case, but all they have to do is prove that it was said. Slander is also treated differently than libel. In slander case, the plaintiff has to prove special damages in order to get their additional double or triple damages. They have to prove that there was some real economic loss in there, especially if it's a business that was slandered. Then they have to be able to prove it that they lost economic damages. Now, with Stephen Curry's wife and her restaurant, she hadn't opened yet. She hasn't lost anything yet. So even if she sues him for libel, all she's going to be able to get is some damages. That's all. Because she wasn't actually opened, it wasn't an actual critique, it wasn't there yet. Okay? Economic or monetary loss did not exist because she wasn't open. A libelous or written statement has the quality of permanence. It can be circulated and results from some degree of thought and deliberation on the part of the author. Somebody has to compose it. Somebody has to think about it. If a statement constitutes slander per se, no proof of special damages is required for the statement to be actionable. There are actually 4 types of utterances considered to be slander per se. They are ancient common law. They really don't apply very much anymore. But one of them is that someone has a serious disease. These days, when someone tells us they have a serious disease on Facebook, what do? We open a GoFundMe account for them. So it's really tough to have slander per se these days, but to have a loathsome disease is one of the 4 utterances. Another one, which is no longer enforced, it's off the books, is that a woman who is being married is no longer chaste. That could be slander per se. See, nobody's even heard of these things. And if you haven't heard of them, they just don't exist anymore.
What do you mean chaste?
Chaste means a virgin. When she's married. That is slander per se to even say that. But that just doesn't exist anymore. Defenses to defamation. Well, the best one is the first one, the truth. The truth is normally an absolute defense. If you say something and it's absolutely true, that is the defense. Privileged speech is also a defense, and privileged speech is divided into 2 categories, absolute and qualified. Okay? Absolute absolute occurs when we have a judicial or legislative matter dealing almost entirely with things that are in the public interest. In court, we have to have people that are able to tell the truth as they see it in order to get to the truth of the matter, right? So they can't be held liable for slander for saying what they believe is true in court, even if it's a lie. They can be prosecuted for perjury later. But if they are, say what they really mean and what they're trying to say, yes, they have absolute privilege. The same thing goes with legislative matters. Any senator, congressman, state senator, state legislator, municipal representative, anybody who gets up in their municipal meeting and says what their constituents are thinking, regardless of how rough it sounds, actually is absolutely privileged to say that, because everybody in that room needs to know what the constituency is thinking so that they can formulate their ideas and vote appropriately. So that is absolute privilege. Qualified privilege. Qualified privilege applies for statements and letters of recommendation. So if you ask somebody to write you a letter of recommendation and they write one and it's not good, if they are or were, I was trying to say the same thing at once. If they are or were your direct supervisor during the time for which you're asking for the letter, they have privilege, even if they don't say good things. If, however, they were not your direct supervisor, and they have decided to ask the person who is next into that position to write it instead, they don't have a qualified privilege. They don't have any privilege at all. If they write something that's bad, they can be sued. So, for statements and letters of recommendation, the individual has to be in the direct line of supervision, which is your direct boss at the time the letter is written for. Or employee evaluations, same thing. Only the person that is in your direct supervisory line that has observed your behavior and your work habits has the privilege of being defensible if they write your employee evaluation. Yes, Robert?
Can you sue anyone for defamation? Like if the vice president or the president were to like defame somebody, then could that person just sue them?
This is a special category. The Supreme Court of the United States has ruled that the President of the United States and the Vice President of the United States has absolute immunity while they are in office.
Anything or just defamation?
To anything.
This is a law.
Unless they waive that immunity. That immunity has only been waived once, and that was by, was it Warren Harding, who was speeding on the street in Washington, D.C. and was arrested by a Metropolitan Police officer. And he said, "Officer, do your duty." And they took him in, and he paid his fine, and then he went back to the White House and was president again. But they are privileged while they are in office.
They should just steal someone and it's fine?
There are exceptions. There are exceptions.
Just like civil stuff.
Just like civil stuff, there are exceptions. There's always a but for every single occurrence or law that we can think about. There's always a but. So anytime you see someone who is in public office say something about someone else who is also in the public light, that's not subject to defamation. You have public figure and you have private figure. Now, as soon as that individual becomes a private figure, he has a qualified right to have a private life. So there are certain things you cannot say about these people. And this person then could be held accountable if they are no longer in office. Okay? Does that make sense? They give you enough information to work on these days? Okay. The individual writing the letter or evaluation must have had first-hand supervisory experience or observation to qualify for the privilege. That goes back to these. Now, here we have the public figure exemption. This is what we were just talking about with politicians. For a slanderous statement to be made about a public figure, the statement must be made with malice. That's the statement must be made with a knowledge that it's false or with a reckless disregard for the truth. But and furthermore, if the statement is made by one public figure about another public figure, then the privilege is extended to that public figure who made it, and it's up to the individual against whom it was made to refute it or to show that it is untrue and reflects badly back on the person who made it. Okay? Invasion of the right to privacy. We have the elements: the use of a person's name, picture, or other likeness for commercial purposes without permission. So I can't use a public figure's picture like Steph Curry. I can't use his picture to advertise my product, and it has nothing to do with him. Okay? And he didn't okay it, and he's not being paid for the use. Intrusion on an individual's affairs or seclusion. So somebody can't be taking pictures of my family through the hedges. Publication of information that places a person in false light. And we talked about false light earlier in the evening. Or public disclosure of private facts about an individual that an ordinary individual could find objectionable. That would be the tabloid kind of exposure. Fraudulent misrepresentation, I explained what that is by use of the exercise bicycle. That's the misrepresentation of material facts, and that can be false or it can be reckless. There has to be an intent to induce someone to rely on the misrepresentation. It has to be a justifiable reliance on the misrepresentation by the deceived party, so the person who is receiving the deception must believe it. And damage is suffered as a result of that reliance, and there must be a causal connection between the misrepresentation and the injury suffered. Okay, I'm going to stop now, let you go get some dinner, and then come back. Because I want to talk about negligence.